Here in the matter of application by Martin Dillon, John McEvoy, Brigid Hughes and Lynda McManus for the judicial review.
Now, we have quite a lot of counsel to hear over the next 2.5 days. In order to avoid chaos, it's very important that counsel should be punctilious about the timings. Otherwise, I'll have to tell people to sit down, and I'd rather avoid having to do that. So please keep an eye on the time. Mr. McLean.
Thank you, my Lord. I appear for the appellant with my friend Mr. James Eadie, Mr. Knight, Mr. McIntyre and Ms. Curran. I think later today you will hear from Lord Wilson. After that, I'm not quite sure what the batting order will be, my Lord, but have the list of the appearances. This is an appeal brought by the Secretary of State in respect of the Northern Ireland Court of Appeal findings in the Dillon and others litigation. It relates to the Northern Ireland Troubles Legacy and Reconciliation Act 2023, the Legacy Act, which was a piece of legislation subject to challenge as soon as it was enacted in 2023. We had 20 judicial review applications lodged in respect to this legislation. 4 of them were selected as leading cases, and the High Court gave judgment in January 2024. You have the judgment in the key documents. There's a 700-paragraph judgment, and the Court at first instance made 2 core findings. First, that 11 of the substantive provisions of the Act were incompatible with the European Convention on Human Rights, and second, that those same provisions were also in breach of Article 2.1 of the Windsor Framework and were accordingly disapplied. And you have the order of the High Court at page 160 of the papers, which is an illustration of the issue. You can readily see that the Court, where it made a finding of incompatibility, also made the same findings in respect of Article 2.1 of the Windsor Framework, and that led to disapplication. Significantly, the High Court judgment dealt also with the capacity of the Independent Commission on Information Recovery and Reconciliation, the ICRIR. It dealt with that on the basis that it had the capacity to operate in an Article 2 compliant manner. So it was a body which continued to do its work in light of that judgment, notwithstanding the disapplication of various provisions, in particular those relating to conditional immunity. The government appealed that decision to the Court of Appeal. The respondents here cross-appealed in respect of the ICRIR capacity point, and the matter was heard by the Northern Ireland Court of Appeal in June 2024. Between the hearing and the judgment, there was a change in government, and having heard all aspects of the appeal in July 2024, the government notified the court that it no longer pursued its appeals against the declarations of incompatibility. So the live issue for the Court of Appeal was issues in respect of the Windsor Framework and the cross appeal. So the Court of Appeal then affirmed the High Court findings in respect of the Windsor Framework, save for one point on the Charter, which we'll come back to. It made further findings in respect of the incompatibility issues, even though they weren't live before it, and upheld the first instance judgment in that respect. But it reversed the High Court rulings in respect of the capacity of the Commission to conduct an Article 2 compliant investigation. And it found for a limited category of cases, because of issues in respect of disclosure of sensitive material and in the involvement of the next of kin, that the Commission could not operate in an Article 2.3 compliant manner. And you'll see a rather convoluted order of the Court of Appeal, which gives that effect at page 342 of the papers. So the result of that is that, in summary, we have a constitutionally profound ruling of the Northern Ireland Courts in respect of the scope of Article 2.1 of the Windsor Framework. It's led to multiple provisions of 2 acts now being subject to disapplication. Provisions in the Legacy Act and provisions in the Illegal Migration Act 2023, which is not before you, but which has been affected in the same way in a case called Northern Ireland Human Rights Commission. The effect of the ruling on scope extends far beyond the issue of legacy investigations, which is before the court, and arguments about disapplication in the scope of the Windsor Framework arise frequently now in Northern Ireland litigation, particularly in the sphere of asylum and immigration, where it's contended that policy changes, legislation or operational decisions are constrained by the effect of the Article 2 provision in the Windsor Framework. Nor is it confined to matters of immigration and asylum. We have potential challenges in respect of the application of this court's ruling in the For Women Scotland case as to whether or not it can apply in Northern Ireland in light of the Windsor Framework. We have challenges to the provisions of the Data Use and Access Act 2025, and currently there are many pending cases in the Northern Ireland courts awaiting the ruling in this case and in others. The second important consequence of this litigation has been that for deaths and injuries which occurred effectively post-1990, there is currently no Article 2 compliant mechanism available for the conduct of investigations because the Court of Appeal have ruled in respect of the Commission that it does not meet the appropriate threshold. That in turn has led to a significant body of litigation, other cases brought before the High Court claiming orders of mandamus, seeking the ordering of public inquiries in order to discharge the state's Article 2 obligation. And one of those cases, a case of Brown, is before this court and has been held back pending the judgment in this case. 4 others are due for hearing in December. Again, the relief sought at the leave or permission stage is for mandatory orders for public inquiries. Third significant consequence of the litigation is that the Court of Appeal reversed the finding of the High Court that a breach of the European Convention on Human Rights also amounted to a breach of the Charter, such as to warrant disapplication. And the Court of Appeal reversed the order in respect of that. That's the subject of the cross appeal in these proceedings. And again, in summary, the consequence there is significant. If it is the case that any breach of ECHR rights in respect of legislation also amounts to a breach of the Charter and fundamental rights, that opens the way to the remedy of disapplication, which takes it outside the normal scope of the statutory scheme in the Human Rights Act. So those are the broad implications of the litigation before the court. I should say also that later today a bill will be introduced in Parliament alongside a remedial order addressing some of the incompatibility findings that have been made in the litigation to date. Those developments, we say, have no bearing on the Windsor Framework issues or the other issues in this appeal. They are matters that are now involved in the parliamentary process, and we propose to say no more about it. In terms of the argument on behalf of the government, I will address the issues in respect of the Windsor Framework and the Charter. Sir James will deal with the issues in respect of disapplication and the European Convention on Human Rights. So we propose to divide on that basis. Starting then with the issues in respect of the Windsor Framework, there are 2 broad issues before the court. The first is the need to analyse the scope of Article 2.1 of the Windsor Framework. That's a question of general importance that cuts beyond the arena of legacy. The second is the case-specific question of whether Article 2.1 of the Windsor Framework has been breached by the Legacy Act and whether the Act should have been disapplied in the manner that it was. So addressing the scope question first, what I propose to do is to consider the relevant national and international instruments that are in play here, then look at the applicable legal principles for the concept of direct effect, and in particular direct effect of international agreements. I'll take the court to probably two key authorities on the point, then examine the question of whether or not the withdrawal agreement and Windsor Framework is capable of direct effect, then consider whether the relevant section of the Belfast Good Friday Agreement is capable of direct effect, and then turn to the Victims Directive. So that's the broad structure of that part of the submission. Looking at the scheme, the regulatory statutory scheme that matters here, the first port of call is Article 50 of the treaty, the EU treaty, in particular Article 53, which you don't need to turn to it, but it's familiar to the court. The treaty shall cease to apply to the state in question from the date of entry in force of the withdrawal agreement. So a function of the Article 50 process being triggered, it set in train a process that led to the formulation of a withdrawal agreement. And the status of that agreement is important for the overall analysis in this case. It's an agreement between the European Union and the United Kingdom, not as a member state. It's an international agreement between the EU and a non-member state, and that impacts on the overall analysis that follows. We invite close consideration to the nature and purpose of the withdrawal agreement and to its broad logic, because we say the interpretive task of this court, the courts below, is to reflect that in the analysis it conducts in respect of the key provisions. The withdrawal agreement in its original 2019 form is found in the papers at page 10,487. Turn to that. The recitals are on that page recording the agreement between the EU and the United Kingdom, Great Britain and Northern Ireland. You'll see the penultimate recital on that page. The parties resolved to ensure an orderly withdrawal through various separate provisions aiming to prevent disruption, provide legal certainty to citizens and economic operators, as well as to judicial and administrative authorities in the Union and the United Kingdom. And we lay emphasis on the legal certainty concept because as we discuss the direct effect analysis in this case, it is underscored by the need to secure legal certainty, and that I hope will come into sharper focus as we develop our submissions. You'll see on the next page at 10,488, again the fifth recital from the bottom, parties acknowledge for an orderly withdrawal of the United Kingdom from the Union, it's also necessary to establish in separate protocols of this agreement durable arrangements addressing very specific situations relating to Ireland, Northern Ireland, and then Cyprus, and then Gibraltar. So that's the structure of the recitals. The definitions section in Article 2 at the bottom of the same page and on to the next identifies the nature of union law, and you'll see from Article 2b the member states outlined there. The UK is not a member state, Northern Ireland is not a member state from this point onwards. Article 4 of the withdrawal agreement is key to the analysis, and the text of this requires close consideration. So the heading is Methods and Principles relating to the effect, implementation and the application of this agreement. And then it says at 4.1, provisions of this agreement and the provision of union law made applicable by this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce in the United Union and its member states. So not all union law, only that which is made applicable by the agreement is engaged here. It goes on to say, accordingly, legal or natural persons shall, in particular, be able to rely directly on the provisions contained or referred to in this agreement, which meet the conditions for direct effect under union law. So the direct effect concept is built in to Article 4 of the withdrawal agreement, and that is key, again, to the overall analysis. We have to establish direct effects in respect of an international treaty in order to understand how Article 2.1 of the Windsor Framework works. Article 4.2 refers to compliance mechanisms and again allows for judicial authorities to disapply inconsistent or incompatible domestic provisions through domestic primary legislation. So there is a route to disapplication where required under the terms of the agreement. And you'll see then the provisions in 4.3 and 4.4 relate to the role of the CJU thereafter. So Article 4.1 is a key provision in the agreement. I want to show you one or two other provisions which are significant for the development of the argument. If you can go to page 10560, 10560, you'll see Part 6 deals with the institutional and final provisions. And on page 10561, you have committees identified. So there's a joint committee in Article 164 between the Union and the United Kingdom, which meets to address particular tasks. You'll see at 1644 at the bottom of the page, they decide on the task of specialised committees and supervise their work. At 10562, Article 165, you will see a heading saying specialised committees, and the following committees are hereby established. And C is the Committee on Issues related to the implementation of the Protocol on Ireland, Northern Ireland. And the significance of that will become clear when we look at the Windsor Framework in due course, but you'll see here a committee structure for consideration of issues under the agreement, a joint committee and a specialised committee on matters relating to Ireland, Northern Ireland. The specialised committee has a particular function, which I'll come to in the Windsor Framework, to address matters relating to Northern Ireland. It does not displace entirely access to the CJU. Matters that are not resolved in the specialist committee can lead to the engagement of an arbitration procedure. That's in Article 170. And if that does not resolve the issues and the issue raises a question of union law, then Article 174 allows for a route to the CJU in those circumstances. And again, you will see how that becomes significant in the Windsor Framework. So there is a circuitous route to the CJU from the specialised committee, and that is another design feature of the agreement. An issue has been raised about whether or not the Commission should be put on notice of these proceedings because of an Article 162 provision. That's on page 10561. The Commission have a facility under the agreement to engage in pending cases before the United Kingdom. They have not engaged in this case to date. I think there's some correspondence about that before the court. I'll return to that later if it becomes significant. I don't think it does. The withdrawal agreement has annexed to it the Northern Ireland Protocol, and if you go to page 10571, you will see the original 2019 Northern Ireland Protocol. It's different from the final version because you will see page 10572 there are provisions in Article 2 addressing the possibility of subsequent agreements. So negotiations were continuing in respect of the Northern Ireland dimension of the withdrawal agreement even after this document was executed. So this version of the Northern Ireland Protocol is not the operative version. The operative version is found in a separate document which begins at 10749, 10749. So this document, now known as the Windsor Framework, after a declaration of the Joint Committee in March 2023, is the operative instrument for our purposes.
So should we work off the original version or the final version?
This version, the 10749 version, my Lord.
Right. Thank you very much.
The recitals are different and some of the provisions are different. And I'm going to start.
Work off the 749?
Yes.
Yes. Thank you.
The recitals, I'll take you to those. First, the Union of the United Kingdom set out the recitals. Look at the fourth one. This is significant. They affirm that the Good Friday or Belfast Agreement of 10th of April 1998 between the Government of the United Kingdom, the Government of Ireland and the other participants in the multi-party negotiations annexed to the British-Irish Agreement, including its subsequent implementation agreements and arrangements, should be protected in all its parts. I highlight that because that's significant in that it disaggregates the components of the Belfast Good Friday Agreement into two elements: the multi-party agreement and the British-Irish Agreement. The British-Irish Agreement is an international treaty. The multi-party agreement was an agreement between most of the political parties involved in the Good Friday negotiations and the British and Irish government. They have different status. And what is protected in the Windsor Framework document hereafter, you'll see it's a defined term, is the 1998 agreement, the multi-party agreement, not the international agreement. Why is that significant? It's significant because there's an issue between the parties as to whether or not the interpretive approach in the Vienna Convention and the law of the treaties should apply to the Belfast multi-party agreement, which we say is not an international treaty. That matters because some of the expansive interpretations by the High Court and Court of Appeal were grounded upon the Vienna Convention approach through Article 31. But we say it's important to identify at the outset that the drafters of the Windsor Framework were very careful to protect the multi-party agreement, not the international agreement. Two paragraphs below, you'll see the heading, noting union laws provided a supporting framework for the provisions on rights, safeguards and equality of opportunity of the 1998 agreement. So the RSEO, RESO as it's sometimes called, provisions are key to the analysis, and they're identified again in the recitals, and those are the provisions not found in the international agreement, found in the multi-party agreement. Three from the bottom, you'll see the objective of protecting North-South cooperation and the guarantee of avoiding a hard border, including any physical infrastructure and related checks. Last paragraph, the objective of avoiding controls. Over the page, 10.750, you'll see further recitals dealing with the commitment to no infrastructure at the border and possible new arrangements for the agreement. So those are the recitals, and having agreed upon all of that, you then have the provisions of the Windsor Framework itself. The Article 1 sets out the general objectives, and you'll see again the constitutional status of Northern Ireland is touched upon. Article 1.3 sets out the arrangement necessary to address the unique circumstances on the island of Ireland, maintain the necessary conditions for North-South cooperation, avoid a hard border, and protect the 1998 agreement in all its dimensions, again, the multi-party agreement. Article 2 of the Windsor Framework is the focal point of this appeal. I'll come back to the text of that for a closer analysis in a moment. But it's useful, we say, to look beyond that to the other provisions in the Protocol or Windsor Framework to see how this was all intended to operate. And the key provisions in the Windsor Framework, apart from Article 2, are Articles 5 and 7 to 10. Those are the key operative provisions. And what these provisions do is make applicable in the law of the United Kingdom various aspects of union law. So you'll see Article 5 deals with customs and movements of goods. Article 5.3 identifies a particular cohort of legislation which shall apply in respect of Northern Ireland. Article 5.4 identifies provisions of union law listed in Annex 2 shall also apply under the conditions set out in that annex in the United Kingdom in respect of Northern Ireland. And Article 5.5 identifies two provisions of the treaty which shall apply. And pausing there, you'll notice that you have a body or corpus of EU law being applied by Article 5, not unconditionally, so there are conditions attached to this. So one has to look into the detail of the annex, and you will see that certain of the provisions do not apply in full. For example, if you go to page 10787, you'll see regulations 10787. This is paragraph 34 of Annex 2. You'll see how this works. You have a regulation, and then you have aspects that don't apply. And you see that at 34. Also happens in regulation paragraph 35 and 43, page 10793. So a corpus of EU law made applicable, subject to conditions, so not all of it is engaged. You'll see similar in Article 7, if you go to page 10755.
Sorry, you're going a little bit fast for me. I'm on 10787. This seems to be about animal feed.
Yes.
And it's an example of?
It's an example of a conditional application. So it's you have the regulations applied, but not all of it. So
I see. Right.
What this goes to is the precision by which the body of law is identified in the Windsor Framework. So it's very precisely defined. You see the same then if you go to page 10755, Article 7. This gives effect specifically to Articles 34 and 36 of the treaty. And again, it's a technical issue about restrictions on imports for public health reasons. And again, you'll see at Article 7.2 a reference to provisions of union law being made applicable. Article 8, 10,756, makes Annex 3 unconditionally applicable. So this is VAT and excise. So the entire corpus of EU law in Annex 3 is made applicable. Article 9 deals with the single electricity market. Again, a conditional application of a body of law there. Article 10 applies Annex 5, subject to certain carve-outs in Article 10.2. So those provisions, 5, 7, 8, 9, 10, are key to the Windsor Framework. Those are the provisions which bring in a defined corpus of EU law. The concept of dynamic alignment does apply, so as those norms change or are replaced, they should also apply in respect of Northern Ireland through the Windsor Framework.
Where did we get that provision?
I can't put my finger on that, Lord. I'll come back to you on that. Then there are some important structural elements of the Windsor Framework. Article 12 provides for implementation, application, supervision and enforcement. And you'll see again Article 12.1 refers to the UK authorities being responsible for implementing and applying union law made applicable by the protocol. Article 12.4 is particularly important. It provides that as regards subparagraph 2 of this article, that's 12, Articles 5, 7 to 10, these are matters that are in particular subject to the jurisdiction of the CJEU. So it has the jurisdiction provided for in the treaties, and also the second and third paragraphs of Article 267 apply. So it's possible to make a reference direct to the CJEU in respect of an issue under Articles 5, 7 to 10 of the Windsor Framework. So the traditional machinery for seeking clarity in a matter of EU law applies there. You will note that it doesn't apply to Article 2.1 of the Windsor Framework. The reference procedure doesn't apply. That route is not available.
I'm sorry, where are you getting that from?
It's because
the
it's
sentence of 12.4.
Yeah, 12.4 refers to a defined number of provisions, my Lord,
Yep.
and doesn't include Article 2.1. The point becomes more obvious when you look to Article 14, and the provision for the specialised committee. You'll see here, I showed you Article 165 of the withdrawal agreement, and it provides for a specialised committee. There are various specialised committees, but there is one for Northern Ireland and Ireland. The committee on issues relating to the implementation of the protocol shall, and then you'll see subparagraph C, consider any matter of relevance to Article 2 of the protocol brought to its attention by some of the parties to this appeal, the Northern Ireland Human Rights Commission, the Equality Commission, or the Joint Committee in Ireland North and South. So the process for consideration of an issue relating to Article 2.1 of the Windsor Framework is not the CJE route, which applies to Articles 5 to 10, but the specialised committee for consideration of these issues. And as I've shown you earlier, that can lead to engagement of an arbitral process, and then if all of that fails, there may be a route on a legal point to CJU. But there's a clear bifurcation in the Windsor Framework. We take one route for the defined corpus of EU law in Articles 5, 7 to 10, and another route for Article 2.1 of the Windsor Framework. Article 18 is also important in this regard. You will see, this is page 10762. This provision allows for democratic consent in Northern Ireland. So, Article 18.1, within 2 months before the end of the initial period and any subsequent period, the United Kingdom shall provide the opportunity for democratic consent in Northern Ireland to the continued application of Articles 5 to 10. Again, that's very important. Articles 5 to 10 will be the subject to a rolling democratic consent process. The mechanics of it aren't crucial for us for these purposes. But every period of years, there will be the opportunity for the people of Northern Ireland to vote on the continued application or otherwise of Articles 5 to 10, on whether the defined corpus of EU law continues to apply. Importantly, there's no facility for Article 2.1 to be the subject of the same process. So, if it is right, as our opponents suggest, that the corpus of EU law, which comes into the UK through the Windsor Framework, includes all civil rights, political rights, charter rights, convention rights, an entire basket of rights that aren't defined in these annexes. If it's right that they come in through this framework, then the democratic consent process doesn't apply. There is no mechanism. Again, these are important pointers, we say, to the correct construction of the operative provisions which we will turn to now. Yes, Lord Stevens asked me about the dynamic alignment provision, and it's to be found at page 10759, Article 13.3.
Article
13.3, my Lord.
Thank you.
Can we then go back to Article 2.1 of the Windsor Framework? This is page 10751. So this bears the heading Rights of Individuals. And you will see immediately the language of this provision is different in character to that which we've seen in Articles 5, 7 to 10 of the framework. The United Kingdom shall ensure, again you will see as we go through some of the materials, that concept of shall ensure is significant. It's a prospective, programmatic concept, so something will happen in the future that will produce certain outcomes or results. Shall ensure that no diminution of rights, safeguards or equality of opportunity. Take that concept. That's a freestanding concept in Article 2.1. So what we are protecting here is non-regression in respect of rights, safeguards, or equality of opportunity. So, pose the question rhetorically, we'll return to it. Is that clause, which is sufficiently precise to give rise to direct effects? The rights, safeguards, or equality of opportunity in play are identified by a pointer to an external source. So the external source is the rights that are set out in that part of the 1998 agreement entitled Rights, Safeguards and Equality of Opportunity. So we're pointing to an external source, which is the multi-party Belfast Agreement. Then that protects those concepts in terms of withdrawal from the Union. There's a further pointer towards another external source and a defined area, which is the area of protection against discrimination, particular sphere of interest, as enshrined in, so not all of, but as enshrined in the provisions of Union law listed in Annex 1 to this protocol, and shall implement this paragraph through dedicated mechanisms. So you have Annex 1, which is to be found at 10,764, and you'll see there 6 specific EU directives, all of which relate to anti-discrimination norms. We don't need to dwell too much on these because none of these are in play in this case. The norms that are in play in this case are not listed. They are the Victims Directive norms, so from another source. The argument in this case is that we step outside the Annex 1 list of directives. We can consider the Victims Directive because it enters the analysis through one of 2 routes, because it is a civil right as defined in the multi-party agreement, or it is a concept that underpins 2 of the paragraphs 11 and 12 of the Belfast Agreement, which I'll come to presently. So our concern is not with the Annex 1 norms, but something outside of that.
I'm sorry. The text here talks about the 1998 agreement, and you're talking about the multi-party agreement and the Belfast Agreement.
Yep.
I'm losing track of which one's which.
Belfast Agreement, I'll use that as the multi-party agreement. The British-Irish Agreement is the international agreement as well. When I say Belfast Agreement, I'm meaning the multi-party agreement. While we've got Article 2, still with page 10751, you'll see there's a separate second paragraph, Article 2.2. UK continues to facilitate the related work of the institutions and bodies under the agreement, that's the various commissions, in upholding their human rights and equality standards. So as we go forward, you will see that specific provisions have been made in statute. And the Northern Ireland Act has been amended to provide particular functions for these bodies. In Section 78 has given expression to the additional powers of these bodies. But our focus for present purposes is on Article 2.1. Can I then take the court to the Belfast Agreement? And if you go to page 10968, this is the document as presented to Parliament in April 1998. It's the agreement reached at the multi-party talks on Northern Ireland. If you go to page 10971, you see the table of contents, which gives you the structure of this document. So the Belfast Agreement, first of all, is a declaration of support. Various constitutional issues are addressed. It has 3 strands, 1, 2 and 3, and then it has a section headed Rights, Safeguards and Equality of Opportunity. and that's the section that is the external source pointed to in Article 2.1 of the Windsor Framework. You will then see at the bottom of the page, it says Annex, Agreement between the Government of the United Kingdom of Great Britain and Northern Ireland and the Government of Ireland. So the international treaty, the British-Irish Agreement, is annexed to this multi-party agreement. If you look to the Declaration of Support on page 10.972, this is a declaration completed by the British and Irish governments and by most of the political parties involved in the multi-party talks, not all. You'll see probably the only reference to legacy in the Belfast Agreement is in paragraph 2. The tragedies of the past have left a deep and profoundly regrettable legacy of suffering. We must never forget those who've died or been injured, their families. Best honour them through a fresh start. And that is, I think, the only reference to legacy in the Belfast Agreement. And it's one of the frequently commented upon features of the agreement that it did not address the past, it did not address legacy, it did not address in detail matters relating to victims, criminal justice, which in one view may be unsurprising because those are issues which were deeply divisive even at this time. The agreement does in places contain text which is highly specific, and you will see if you look at the constitutional issues section, page 10.973, there are draft clauses included, page 10.974, in respect of the constitutional question, i.e. will Northern Ireland remain part of the United Kingdom or not? And those clauses, you see them for British legislation and for Irish legislation. The Schedule 1 clause, 10.974, was effectively enacted in the Northern Ireland Act. So there are some elements of the Belfast Agreement which were drafted in such a way that they could be directly enacted in legislation, as this was. And there are other provisions that are very different in character. The focus of our attention is on the rights, safeguards and equality of opportunity section. And you will find that at page 10.987. And you see in the first paragraph, the parties to the agreement affirmed their commitment to the mutual respect, the civil rights and the religious liberties of everyone in the community. That first sentence has become very important in this litigation. It is contended by the respondents and by the commissions involved that the concept of civil rights in that first sentence is in effect a portal through which a great corpus of EU rights and norms will flow. So civil rights can be interpreted to include all social and political rights, charter rights, convention rights. That's the contention. And that's the contention which the Northern Ireland High Court and Court of Appeal have accepted. So a conceptual question for us is whether or not that is the true effect of the inclusion of that term in that sentence, whether it can have that direct effect or not. First point we'd make about it is it has to be read in its context. The word civil rights certainly appears there, but it's an affirmation by the parties of their commitment to mutual respect, the civil rights, religious liberties, a basket of issues of notable generality. And we say, again, that colours the analysis to whether or not it can truly have a direct effect. Then the second sentence says, against the background of the recent history of communal conflict, the parties affirm in particular there were 8 identified bullet-pointed rights, and you'll see them there. These are, again, expressed at a significant level of generality. Notably, there's nothing there about victims, nothing about the legacy of the past, nothing about asylum and immigration, nothing about redress mechanisms, inquests, investigations. These are expressed, again, at a high level of generality. Then you'll see a greater level of specificity in the heading section under the heading United Kingdom legislation. So the British government will complete incorporation into Northern Ireland law of the European Convention on Human Rights with direct access to courts and remedies for breach of the Convention. That was done because contemporaneous with the Northern Ireland Act, the next act in the statute book is the Human Rights Act. So they were enacted almost simultaneously. So that was given expression in the Human Rights Act. The power for courts to overrule Assembly legislation on grounds of inconsistency was given effect in the Northern Ireland Act in Section 6 and Section 24. So again, the specificity was reflected in the actual enactment in the legislation. Paragraph 3 refers to introducing statutory obligations of public authorities to fulfil equality duties. That was given statutory effect in Section 75 and Schedule 9 of the Northern Ireland Act. Again, directly translated into the statutory scheme. There is limited reference to victims and victims' rights in this part of the agreement. The key paragraphs on this are in paragraphs 11 through to 13.
They actually contemplated in paragraph 4 that there would be a new Bill of Rights for Northern Ireland.
Yes.
They were actually
It didn't happen.
trying to work out what rights should apply in Northern Ireland.
Yes. And the Bill of Rights process, the Lord will know, never delivered anything. So page 10989, under the heading Reconciliation and Victims of Violence, the participants believe it's essential to acknowledge and address the suffering of the victims of violence as a necessary element of reconciliation. They look forward to the results of the work of the Northern Ireland Victims Commission. So the concept of reconciliation, which of course features in the 2023 Act, it's been challenged and disapplied, was a feature of the paragraph 11, but no identified right, nothing specific in all of that. It is looking forward to the activity of another body, the Northern Ireland Victims Commission, which ultimately fed into the policy development process. Paragraph 12, it is recognised that victims have a right to remember as well as a right to contribute to a changed society. Those are the only two identified victims' rights, if that's the correct description, in the Belfast Agreement. So the right to remember and to contribute to a changed society. The Court of Appeal in their judgment say one can infer from that the right to have access to inquests and investigations. They say it follows as night follows day. And we say, again, that's a flaw in the analysis. What we have here is a right to remember and contribute to change society. If one actually looks at the Legacy Act 2023, there's an entire section, part 4 of that Act, addresses information recovery, remembrance, memorials, historical archives. None of that was actually challenged in the 20 judicial reviews that were brought against this Act. That aspect of the Belfast Agreement was delivered and remains intact in the 2023 Act itself. So the portals, the two possible portals for the EU norms that are in play here are those paragraphs, 11 and 12, and the civil rights concept in paragraph 1. And as the litigation has developed, the focus has shifted away from paragraphs 11 and 12, those identified rights, towards the concept of civil rights. And you will see the two commissions emphasise very heavily the scope of the civil rights concept in article, the first article of that paragraph. The agreement then also has provisions in respect of, for example, prisoners at page 10.996, which allowed for quite controversial and novel schemes of accelerated release. So people who've been convicted of the most heinous crimes were released after serving very short periods of time in prison. Legislation was enacted to give effect to that. That's in paragraph 4. We had Sentences Act, which have been applied and modified again to minimise the length of time people spend in custody for those troubles-related offences. Again, a feature of the agreement. The British-Irish agreement itself is then found at page 10998. And this is the instrument which we say is truly the international treaty, which the Vienna Convention, the law of treaties, can be said to apply. It's separate from the multi-party agreement. And it says, again, nothing of substance in respect of legacy matters, victims' rights. It does affirm in Roman numeral 5, page 10999, that whenever the constitutional choice is exercised on the future status of Northern Ireland, it should be done with rigorous impartiality on behalf of all of the people, shall be founded in the principle of full respect for and equality of civil, political, social and cultural rights, freedom of discrimination for all citizens, parity of esteem, just and equal treatment, and so forth. These are concepts to be engaged in the event that we elect to change our constitutional status. Beyond that, the agreement says, the British-Irish agreement says nothing more about those issues. Now, how does this link to primary legislation in the United Kingdom? How does it link to the Legacy Act itself? The answer to that is, again, found in the EU Withdrawal Act 2018. The court will be familiar with this. It featured in the Alistair litigation.
Will you be coming back to the British-Irish agreement at some stage?
Well, I can do, my Lord, yes. Is there a particular point you want me to touch upon?
Yes, because Article 2 says the two governments affirm their solemn commitment to support and, where appropriate, implement the provisions of the multi-party agreement.
Yes.
And the multi-party agreement, including the RSEO, is annexed to the agreement.
They're annexed to each other. It's a circular process. You have each annexes the other, and that's correct.
It relates to the argument about the Vienna Convention.
Yes.
If there were a challenge to the performance of a government in relation to Article 2, is it your submission that the terms of Article 2 would be interpreted in accordance with the Vienna Convention, but the court would then have to apply different interpretative tools to the annex to the treaty in relation to the multi-party agreement?
Yes, Lord. And that's been the approach our courts have adopted to date in respect of the multi-party agreement. It's never been interpreted as if it were an international agreement, even though it is annexed to the Belfast Agreement and they annex to each other. Probably,
yes, but if you're working out whether or not a party has implemented the provisions, don't you have to understand what those provisions are?
Yes. And those provisions in the multi-party agreement themselves are not subject to the construction of mandated by Article 31 of the Vienna Convention Law of Treaties.
That's your position.
Yes.
That you have to have a bifurcated interpretative exercise. Look at the treaty with one set of rules. Look at the multi-party agreement with a different set of rules.
And
thank you,
Lord, you can see textually why they're actually structured in a different way. The language is different, the formatting is different, all of that's different. But also, perhaps even more importantly, the parties to the multi-party agreement did not have treaty-making capacity. These are not states. These are they're not the totality of the political actors who were involved in the negotiations. So those who engaged in the multi-party agreement did not have the capacity to execute an international treaty.
No, indeed not.
And that, we say, underscores the reason for a different approach.
Yeah, I just wanted to understand if the logic of your position was that in a challenge to the implementation of the treaty, the courts would have to apply a bifurcated approach. That's right. The answer is yes, they would. Thank you.
Do we have the Vienna Convention in the papers?
Yes, we do.
10.860. 10.860 according to you.
10.860.
Yeah. So, as one might expect, it's a rule that applies to treaties.
Yes.
Yes.
Exactly. So Article 31 is the operative provision.
And annexed to the treaty is a part of the treaty.
Annexed to the treaty is, the multi-party agreement. We say that's a separate document.
Is that a part of the treaty?
We say no, it's not.
And treaty is defined, we don't have the paragraph, but treaty is defined in the Vienna Convention as an agreement between states.
Yes, that's right. And that's why we say the multi-party agreement can't be that. It's not a central point in the case. It's a point about whether one can have a particularly expansive interpretation of the multi-party agreement. And we say no, for other reasons as well, one ought not to.
It is an important point of the case with respect, because the government explainer on which the respondents rely would come into strong focus if the Vienna Convention were to be the applicable model for interpretation.
Yes. Well, again, the explainer, we say, is not a critical document for exactly that reason.
Yes, that's what I'm saying. It's an important argument as to whether or not the annex is part of the treaty, or as you would have it, there is a bifurcated approach to interpretation.
The approach we argue for has been the approach adopted by the Northern Ireland courts since 1998. Indeed, one of the members of the Court of Appeal, was Justice Schofield, gave judgment in a case called NICA, which is in the papers. I'll give you the reference in due course, affirming that position. So that's been the understood position in respect of Northern Ireland jurisprudence to date. Yes. The departure came in High Court in Dillon, affirmed by the Court of Appeal. We say that's a wrong turn, but I'll come to it. But even if we're wrong about all of that, we say there's nothing in our analysis now that's inconsistent with the explainer in any event. So, but
you took us earlier to the Windsor Framework, which had an annex which set out about 8 EU directives.
Yes, Annex 1.
Now, if you had an annex to the British-Irish Agreement, which referred to 8 EU directives, on your argument, you wouldn't apply the Vienna Convention to the interpretation of the EU directives. The argument against you seems to be that you would.
Yes. Well, our position is, as I've outlined, you wouldn't, there's a straightforward reason for that. As I've said, the key point is the capacity of those who are enacting that agreement, who were the British and Irish governments, who had treaty-making capacity, and the political parties who didn't. And again, that's reflected in the nature of the document itself. The Belfast Agreement itself is open-textured in its language, at times highly specific, at times extremely general, and that reflects the character of the document, not intended to be and was not an international treaty.
And your reasoning would be that the directive doesn't become an agreement between states by virtue of being annexed to an agreement between
states. It's a freestanding EU norm in itself. Yes. Different ways. I wanted to just take you briefly to the EU Withdrawal Act provisions to show how this connects together. So if you go to page 5138, you have the European Union Withdrawal Agreement Act 2020. And again, this is towards the end of the negotiation process, whenever we were about to complete the EU exit exercise. It introduced various amendments to the 2018 Act, and that included a new Section 7A. So this is the general implementation of the remainder of the withdrawal agreement. So we're now at the end stage of the process, a further amendment to the 2018 Act, and Section 7A is in effect an analogue of Section 2.1 of the European Communities Act 1972. And some of my lords were involved in the Alistair case and will recall this provision. This provision operates effectively as the conduit pipe through which the corpus of EU law will flow into the domestic legal system. Now, under Section 2.1 of the European Communities Act 1972, there was a vast reservoir of EU law which flowed into the domestic legal system. Under Section 7A, the corpus of law is different. It is as defined by the withdrawal agreement. So, again, the purpose, nature of this is categorically different. And on one view, we can easily identify what's within that corpus of EU law because it's the Articles 5, 7 to 10 and the annexes, subject to dynamic alignment as it develops. And then there is the area of dispute, which is the extent to which there's an additional corpus of law which travels through the portals in the rights, safeguards and equality of opportunity aspect of the Belfast Agreement. And you'll immediately see the issue, because if we have the expansive interpretation argued for by the respondents based on civil rights, with the dictionary definition of what that means, all social and political rights, the corpus of EU law which flows through the conduit pipe is categorically different. It comes much closer to the reservoir of norms that were available under Section 2.1 of the 1972 Act. So that's the critical issue in the case. So Section 7A itself doesn't do anything other than provide that facility. You'll have the explanatory notes in respect of that, if they're of any assistance to the court, at page 5142 through to 5144, which describe how the mechanism is meant to work. So, going back to the withdrawal agreement in Article 4.1, which I started with, you will see the critical concept as to what is made applicable is the concept of direct effect. And I'll address this first at the level of generality. The direct effect
depends on the rules of direct effect in EU law.
Yes, exactly. But direct effect, again, the point I was coming to, my lord, not just EU law, direct effect with respect to international agreements and EU law. So it's the interface between the international agreement and EU law and the member state which matters. So it's not just ordinary direct effect, it is that particular category of cases.
It's a body of law, of EU law, relating to international agreements with non-member states.
Yes. So this is, again, as I've already foreshadowed, an issue that engages the legal certainty safeguard. So legal systems need to know what is coming in through this concept in Section 7A and Article 4, what is going to take primacy over domestic law. That is why the concept of direct effect matters. There's a classic excursus on direct effect in Lord Newburger's judgment in Miller No. 1. You don't need to go to it, but for your reference you'll find it, page 7141, paragraph 63, which discusses direct effect as an EU concept. We are, as I've said, engaged with the more refined analysis of the test for direct effect of an international agreement. And there's a great deal of authority been cited to the court, multiple instances of discussion of this issue, but I want to take you just to two of those. And the first case I want to look at is a case called Demerel. It's a 1986-87 decision. You'll find it at page 8827. So this is a CJU case about the effect of an association agreement. So the other state involved here is Turkey. It's an association agreement between the European Union and Turkey with respect to certain rights of citizens. You'll see that set out at page 8810 in the head note. Refers to special privilege links with a non-member country, allowing them to take part in the activities of the community system. So this is a Turkish association agreement case. And the particular clauses under consideration are identified in the opinion of the Advocate General. If you go to page 8820. 8820, my Lord. And the issue here is about freedom of movement for Turkish workers in the EU. So halfway down the paragraph, you'll see reference to Chapter 3 of Title 2 and Article 12. And then the operative provisions that are engaged here are Article 36p and Article 7. And you'll look at the text indented there, referring to freedom of workers between member states of the community and Turkey, secured by progressive stages in accordance with the principles set in Article 12 of the Agreement of Association between certain dates, and the Council shall then decide on the rules necessary to that end. And Article 7, the text again, I won't read it, but it's indented there. So the question is whether or not those provisions can have direct effect in EU law. And you'll see over the page in 8821 the view of the Advocate General. Respect of Article 12, in the first paragraph, last sentence, was it didn't contain any clear, precise, unconditional obligation. It merely outlines a programme and cannot have direct effect. Similar analysis at the bottom of that page in respect of Article 36p, also not effective. The judgment begins at page 8824. The facts aren't crucial for our purposes, but you can see the detail in paragraph 2. The question for the court is at 8826, whether Article 12 and Article 36, read in conjunction with Article 7, are directly applicable. And then the test, the Demerel test, is set out. A provision in an agreement concluded by the community with non-member countries must be regarded as being directly applicable when regard being had to its wording and the purpose and nature of the agreement itself. The provision contains a clear and precise obligation which is not subject in its implementation or effects to the adoption of any subsequent measure. That's the critical test for the direct effect of an international agreement in EU law. So one looks in particular to the wording, the nature and purpose, and then the classic requirement for clarity and precision, and not being subject to any other ancillary steps. On the facts of that case, you will see paragraphs 23 to 25, page 8828. Referring to Article 12 and Article 36, they essentially serve to set out a programme and are not sufficiently precise and unconditional to be capable of governing directly the movement of workers. Not possible to infer from Article 7 a prohibition of the type sought. And then consequently, the answer to the first question is they are not directly applicable in the internal order of the member states. So Demerel test is important. We say it directs consideration to the nature and purpose of the overall agreement, directs attention to the wording, clarity and precision, and the question of any subsequent measures. So we ask ourselves again, looking back to Article 2.1 of the Windsor Framework, is it programmatic in its nature? The Windsor Framework sits within the withdrawal agreement. The nature and purpose of that agreement is to cease the application of EU law, to exit the European Union, for Northern Ireland and the United Kingdom, and within the United Kingdom to no longer be a member state, but to make provision for a particular corpus of EU law as defined in those provisions. So the nature and purpose is not just the purpose of the protocol, but the purpose of the withdrawal agreement. The second CJU judgment I wanted to highlight was, I'm calling it the Slovakian Brown Bear case because I can't pronounce the actual name of it, but henceforth Slovakian Brown Bear case, found at page 9539. So this is a Grand Chamber judgment from 2012. So Demeral's an 86 case. This is much, much later. And it's litigation about the potential direct effect of provision in the Aarhus Convention, which again will be familiar to the court, impacting on decision-making in respect of environmental matters. And the applicant were a pressure group dedicated to the preservation of environmental matters, including the bear, and they were contending that they should be able to rely directly on Article 9.3 of the Aarhus Convention. And you'll see that provision. I'll take you to the judgment. Yeah. If we go to the judgment of the court, page 9563. Article 9 of the Convention, Article 9.3, halfway down that page. In addition, and without prejudice to the review procedures, each party shall ensure that, you note the formula there, where they meet the criteria, if any laid down as national law, members of the public shall have access to administrative or judicial procedures to challenge acts or omissions by private persons, etc. So that's the obligation. Obligation to ensure that they can have access to administrative or judicial procedures. And the question is whether or not that part of the Aarhus Agreement gives rise to direct effects. You'll see the question framed at page 9568, paragraph 28. And then at page 9570, paragraphs 44 and onwards. The court doesn't actually refer to Demeral, but it refers to some later authorities. But it's a repetition of the Demeral test. A prison agreement concluded by a European Union with a non-member country must be regarded as being directly applicable, regard how to its wording, purpose and nature, etc., and to the possible adoption of any subsequent measure. It cites other authorities to that. It must be held that the provisions of Article 9.3 of the Aarhus Convention do not contain any clear and precise obligation capable of directly regulating the legal position of individuals, since only members of the public who meet the criteria of any laid down by national law are entitled to exercise the rights provided for in Article 9.3. That provision is subject to implementation effects to the adoption of subsequent procedure. And then at paragraph 52 again, the answer is it doesn't have direct effect. So again, one looks to the nature of the Aarhus Convention, which is an international agreement, properly so called, looks to the language that's used, and one compares that to the linguistic devices used in Article 2.1 of the Windsor Framework. You see some similarities, the shall ensure concept, but then one moves into the vagaries of rights, safeguards, equality of opportunity, pointing to an external source, which itself we say is replete with uncertainty, and in our submission, applying the approach in Demeral and Slovakian Brown Bear, the answer should be that those provisions cannot give rise to direct effect. Now, in this case, you'll note from the Northern Ireland Court of Appeal judgment that when they grapple with the issue of direct effect, this is found at page 351 of the bundle, paragraphs 84 through to 86. Although these authorities were certainly discussed and were before the court, they don't engage with the Demeral test. They don't engage with the Slovakian Brown Bear analysis.
Could you give me the page number again?
351, my lord, sorry.
351. My fault.
That's actually the beginning of the judgment.
Sorry. 84 is the paragraph 84, I think. Yes, 381. Yes, if you actually go back to 380, you'll see the analysis begins at paragraph 82, and the Court of Appeal discussing EU law concepts, direct effects, but they take the authority of Van Gendon and Loos, that's not about international agreement direct effect, that's about internal EU instrument direct effect, and they build on that.
Which paragraph?
That's paragraph 82, my lord. You see at 83, recording of the government argument, which was you have to establish direct effect at every level. Article 2.1 itself, the text of Article 2.1, the terms of the Belfast Agreement and the RESO section, and the Victims Directive itself. The court rejected that. Importantly, at paragraph 84, you'll see the court accepted a submission we had made that the Belfast Good Friday Agreement was not drafted with that type of precision in mind. And that type of precision is the type of precision that is necessary for direct effect. Whether one takes the straightforward EU analysis under Van Gendon Loos or one takes the elevated analysis required of an international treaty under Demerel, that's a critical feature of the Court of Appeal judgment. Their view was, in accordance with the government view, that that aspect of the Belfast Agreement wasn't drafted with that type of precision in mind, and we say that is absolutely correct. However, what should flow from that, we say, is a severing of the chain that allows for the establishment of direct effect. If you cannot establish the necessary clarity and precision in terms of those provisions of the Belfast Agreement, then you can never establish the necessary direct effect. That's the only conclusion that was open to the court, having made that finding. But that's not, of course, what happened. You will see paragraph 85, the court doesn't follow through on the logic of its own analysis. They find Article 2.1 Windsor Framework is directly effective. The non-diminution guarantees expressed in clear and unambiguous terms. They refer to Van Gendon Loos, identify that as a straightforward negative obligation assumed by the UK. The meaning speaks for itself. The nature of the prohibition makes it ideally adapted to produce direct effects in the legal relationship between the state and its citizens. They then note that there will be a need for further analysis on the concrete facts of any given case, but the obligation assumed in Article 2.1 is a clear and unconditional obligation of result. So that's where the court went, and that is really the analysis, the key analysis on that point.
So you say that Article 2.1 may give rise to direct effect in relation to the annex directives. Is there any other respect in which you say it can do so?
In some aspects of the annex directives, so not all of them, yes. So some provisions subject to that. It's difficult to be categorical about it. It may not be confined to the Annex 1 directives. One can possibly see other scenarios. Let's say, for example, hypothetically, religious discrimination is addressed in Northern Ireland by the Fair Employment Treatment Order. It doesn't have a parent in one of those 6 Annex 1 directives. But if we were to introduce primary legislation that reversed the Fair Employment and Treatment Order, that might be something that runs against a direct effect not in Annex 1, and it goes right to the core of the Belfast Agreement, goes right to the core of the issues that give rise to conflict. Something like that might be sufficient, but the more likely source is within the Annex 1 directives themselves.
I can't quite follow that. Sorry. Change, if you can just talk me through that again.
Well, I'm hypothesising, Lord, perhaps if one's looking for a reversal, it could be fair employment legislation or race relations legislation, for example. That might be something that engages through either the Annex 1 directives or outside the Annex 1 directives, an EU dimension, Lord, that gives it an underpinning. So we don't say the category is closed around the Annex 1, but it'll be a rare and limited case where that happens.
It's an odd thing to have agreed the Windsor Framework on the basis that some parts of Article 2.1 were intended to have legal effect and other parts were intended to be purely political.
Yes. Well, I mean, there's a different analysis, which is that none of it's intended to have legal effects, that it's all intended to be purely political. But that abrades with the
But
fact.
that is not your the Secretary of State's position.
No, and the difficulty...
That's what I'm saying, but the position you're taking is an odd one for a government to have taken at the outset.
Yes. Well, again, it confronts the realities of the identified norms, for example, in Annex 1. Because within those norms there will be enshrined provisions which will have direct effect. I don't identify them, I don't need to identify them, and there may not be many, but that's the position that we have. But it doesn't follow from that every aspect of Article 2.1 has direct effect, nor everything identified in the external reference points in the Belfast Agreement has the same consequences.
No, but the difficulty is that you rely in the Brown Bear case and Demerel on language about shall ensure and so on as being political, and we see exactly the same language in Article 2.1, and yet you accept that not only aspects of Annex A of the protocol take legal effect by virtue of Article 2.1, but also possibly other matters to which you've just referred.
So I can't exclude the possibility, nor I don't put it any higher than that. I think that's the limit of the concession we make in respect of that.
You did show us earlier that Article 2.2 was subject to references to the CJEU, whereas Article 2.1 wasn't. That was in that's in the protocol itself.
Yes.
Article 12.
Article 12. I don't think Article 2.1 or 2.2 is involved, not Article 2 in total.
Well, I wrote it down. It was yes, 12, paragraph 4. As regards the second paragraph of paragraph 2 of this article.
Yes, sorry.
Yes.
That's right. No, I think the second paragraph, if you're looking at paragraph 12.4,
Yep.
page 10758.
Sorry, page?
10758. It's reference to paragraph 2 of this article, which is 12.
Oh, I beg your pardon.
Yes, not 2.
Yes, yes.
So all of 2 is out in terms of the CJU process, save for the arbitration exercise.
Thank you.
The Human Rights Commission puts forward the argument that the result to be achieved is sufficiently precise. It's not necessary for the category of matters which are the subject matter of that result to meet the test for direct effect when examined in isolation. That's their argument.
Yes.
They rely upon Zemmour and Koch and a couple of other authorities. Yes. What do you say about that?
It's a striking feature of the Respondents case and the 2 Commissions case that they seek to avoid or sidestep the question of whether the Belfast Good Friday Agreement dimension has direct effect. They say you don't need to worry about that because just look to the end result or look to the first part of Article 2.1. So they avoid the question, which I've highlighted. They say it doesn't matter that it doesn't identify rights. It's enough that it identifies a category of rights. That's the Human Rights Commission position. We say that is an exercise simply in labelling. The fact that it's a category of rights doesn't help. That doesn't bring any greater clarity or precision to the corpus of law than describing them as actual rights or sources of rights. So whether it's a source or a category really doesn't answer the question. The question remains, can it be said that the reference to the RESO part of the Belfast Agreement is sufficiently clear and precise to give rise to direct effect? That's a question which Respondents and the Commissions are keen to avoid. Keen to avoid it because the Court of Appeal have answered it correctly. that it wasn't drafted with that kind of precision in mind. And if that's right, then the entire sequence is broken. You cannot get to the end result of direct effect on that point. And so there are novel arguments developed in respect of that, and that's one of them, to describe it as a categorization exercise. We say it doesn't provide an answer, but it's telling, we say, that that's the one issue which those on the other side of the court are not keen to engage on directly.
Just to make sure I'm following your argument, the Court of Appeal quoted the words, "The UK shall ensure that no diminution of rights results from its withdrawal from the Union," and they say this is a straightforward negative obligation.
Yes.
As I understand it, your argument isn't that the words "ensure no diminution results," etc. That's not the problem. The problem is the lack of definition of what we mean by rights.
Exactly. Exactly. And again, it's crystal clear when we go back to the Belfast Agreement itself. I've identified what I describe as the targets. The targets are the use of the word civil rights in the first sentence of the first paragraph, or the reference to victim rights in paragraphs 11 and 12. In particular, the civil rights concept. Is that considered, again, in the nature and purpose of the Belfast Agreement, is that sufficiently clear and precise to identify a body of rights that will flow through Section 7A? We say, evidently not. That's what the Court of Appeal found. In support of that, we suggest that the Court of Justice would take the same approach, and we've identified the decision in an Irish case, went to the CJU Clone and Board Planala. That's at page 9435.
Page, sorry.
9435.
Before looking at that, my understanding of your argument is that there is a clear prohibition of doing something. It can't be clear and precise unless you know what it is you're prohibited from doing.
Yes.
And you say that a reference to civil rights doesn't give you that definition.
Definitely not, Lord. It doesn't give you that. Again, cutting back to the concept of legal certainty, which must underpin all of that. How are we to know whether primary legislation should be disapplied? How are we to know when we're formulating policy whether it will be struck down for being inconsistent with the concept of civil rights in the Belfast Agreement? It's an inoperable concept. And that, in fact, has been the case for almost 2 years now, since we had this judgment in Dillon, in the context that I've already outlined to the court. And Board Planala is a CJU decision from 2019. It's at 9435. And we flag this authority because it's a helpful example of the court looking at open textured language, quite analogous to the Belfast Agreement language, we say, and considering whether or not it has direct effects. So it's a planning case. Again, it's about the direct effect of a directive against a member state, but also it's the same language as is used in our House Convention. So this is our House Convention, Article 9.4. The other case was Article 9.3. So if you go into the text of the judgment, which begins at 9465 and on into 9466, you'll see Article 9 of the Our House Convention at the bottom of the page, and then the various provisions. We've already looked at 9.3. This case is about 9.4, and the issue here is about the provision in 9.4 about providing adequate and effective remedies, including injunctive relief as appropriate, and be fair, equitable, timely, and not prohibitively expensive. So the actual focus of the court here is on the concept of being not prohibitively expensive.
Which part of page
9467, Lord, sorry, going on to that, it's a quotation from Article 9 of the Our House Convention, section or Article 9.4, and the NPE obligation not prohibitively expensive. And the analysis of this is found from paragraphs 25 onwards. You see at 26, Ireland had not transposed the Aarhus Directive, or the sub-directive, as amended, therefore had included that part. You'll see at 27, the concept of direct applicability considered. 28, discussion of the nature of a precise obligation. 29, given the general nature of the words used, it's difficult to envisage how those provisions may be regarded as imposing sufficiently precise obligations on Member States in order to dispense with national implementing measures. Discussion of more authorities, then cross-referring to the Aarhus Convention. And at paragraph 33, reference again to Demerol. So the not prohibitively expensive rule in the 5th paragraph does not have direct effect. So again, a helpful barometer for what the CJU would consider in the context of an international agreement provision as being directly effective. The concept of not prohibitively expensive was found not to be sufficiently precise to give rise to direct effect. We say, by parity of reasoning, the same applies to the unidentified provisions of the Belfast Agreement, which are pointed to by Article 2.1 of the Windsor Framework.
So that paragraph suggests it's the same test.
Yes. Yeah. Exactly. So, as I've said, the focus of the argument now from those on the other side of the court is on the concept of civil rights in that part of the Belfast Agreement which I've already alluded to. It's contended that the Victims Directive, which is in play, not an Annex 1 directive, but is in play, it's said in this case, it comes in through the civil rights protection, has primacy, and can be used to disapply the provisions of the Legacy Act. And of course, that's what the High Court found. Disapplied 9 substantive provisions. The Court of Appeal disapplied, I think, 10, and based on that civil rights portal. You'll see also, sketching the argument to come, that the cross appeal argues that civil rights also brings in the charter rights. So where you have ECHR rights said to be in breach or breached, that can be read across to include the charter rights. If charter rights are brought in through the portal of civil rights in the Belfast Agreement, the consequence is, rather than just having a Section 4 declaration of incompatibility, you disapply the legislation. A court can disapply the legislation. So the court can immediately see how we're in a radically different place than we might have been had there been the narrower construction of the Windsor Framework. Rather than a small pool of EU law as specifically defined in the Annex, we have the reservoir of social, political rights, which it said can come in through this particular channel. And that's why, again, the Demerol analysis is important. We must reflect on the nature and purpose of the withdrawal agreement. What was the withdrawal agreement trying to do? Can it be construed against itself to have an effect which appears to be at odds, or at least abraded with, the idea of ceasing to be a member state and ceasing to be subject to union law, save for a narrowly defined category? And our submission is the analysis of the Court of Appeal abrades with the nature and purpose of the withdrawal agreement, if it is followed to its logical conclusion. So Lord Stevens has asked me about the counter-arguments advanced by the Human Rights Commission. In respect of this, I've dealt with the categorisation point. There's a lot of authority cited to the court suggesting a different approach has been applied in association agreement cases. So there are multiple citations of cases involving association agreements. Those cases tend to be different in character because the rights in question are readily identifiable. They tend to be workers' rights, rights to benefits or to pensions, which are linked to having a particular nationality. So if you come from Morocco, you're working in a member state, you have rights to occupational pensions, that's defined in the association agreements. At a high level, we say those association agreements are different in character from the multi-party Belfast Agreement because you have defined concepts which have sufficient clarity and precision to be given direct effect. So again, we say the external instrument we're talking about in this case is of an entirely different character. And again, that would have been clear when the clause were drafted. It's notable, we say, that the Equality Commission, who are, again, ranged against us in this case, except in their case, I'll give you the page reference, page 246, paragraph 27, page 261, paragraph 70. They accept that the rights, safeguards, equality of opportunity commitments were seen at the time they were enacted as political commitments and not in themselves giving rise to legal obligations enforceable in the UK domestic courts. They put the point even more firmly in paragraph 70 of their own written case. We agree. Those were political commitments. That's the nature of the language that was used. It's open textured and deliberately so. The provisions of the Belfast Agreement were, in the main, not directly enacted in the Northern Ireland Act. They were translated, some of them, not all, into statutory provisions. Again, that reflects the essentially political nature of those particular commitments. And that explains the Court of Appeal's analysis, accepting our point at paragraph 84 of their judgment. So the Equality Commission were right and are right to accept that. Nothing has changed since 1998 to alter the character of the commitments that have emerged in that agreement. They remain the same. The character is the same. They're essentially political commitments. And one cannot extrapolate from those commitments rights to legal remedies and avenues which they do not themselves express. The Court of Appeal went wrong here too, we say. Paragraph 116 of their judgment. They say the paragraph 11 and 12, obligation to address the suffering of victims.
So what page is this?
Page reference, I'll get you, my Lord.
I think it's 393.
393. Yes.
Can I say, I think we would probably all find it helpful if somebody could provide us with a note of the critical provisions and the pages where we find them. Because it's a sort of Russian dolls or layers of an onion, this.
Yes.
I mean, you've got section 7A of the 2020 Act. It's a sort of normative apex. And then you've got Article 4 of the withdrawal agreement. And then you've got Article 2.1 of the revised version of the protocol. And then the next sort of step is the door inside that, if you like, is the Belfast Agreement, Article 2.1. Is it? No, beg your pardon. The section on
RSEO section.
The section on rights, safeguards, and equality of opportunities. Yes. And if we had I think speaking for myself, and maybe speaking for colleagues, if we had just a note of those and the electronic pages that might help us to navigate more quickly.
Yes, Lord. There are 11,000 papers, 11,000 pages here. We don't need 11,000. It can be distilled to a much more narrow volume. We'll do that on our side, Lord.
Thank you.
I was on the Court of Appeal analysis, page 393. Referencing victims' rights.
Paragraph
116. Court of Appeal rejected the government's submission that the victims' rights were limited to the right to remember in paragraph 12. We say that is, we maintain the case that's the only operative right there. Importantly, the suffering of victims of violence was to be acknowledged and addressed. An element of this is plainly addressing these issues by means of legal remedies and avenues which have long been recognised as securing a measure of justice for victims. One cannot extrapolate from the provisions in paragraph 12 of the Belfast Agreement any issue about legal remedies, avenues for redress, securing a measure of justice for victims. In fact, notoriously, that's what the Belfast Agreement didn't address. That's why we spent 20 years trying to come up with a legislative solution to these issues. The whole point of the Legacy Act is to address the lacuna that arises in that context. So the Court of Appeal have, we say, taken a complete wrong turn in respect of that. This is the problem, not the solution. And nothing flows from that. As I've indicated previously, where the Belfast Agreement does intend to have particular legal consequences, it descends to particularity. So I showed you the constitutional issues section, the clause which became Schedule 1 of the Northern Ireland Act. I've shown you the clause that gave rise to Section 75. It can have precision to a certain extent, but not in the aspects which we are considering and which are relied upon by the respondents in this case. So the central issue on the scope argument in this case is, we say, the correct interpretation. When you cascade through all the elements, as my Lord's described, and you get down to the Belfast Agreement and you get down to the civil rights component, is that sufficiently clear and precise to give rise to legal effects? And in our submission, the answer to that has to be certainly not. It doesn't. And if that's right, then
dealing with civil rights at the time of the Belfast Agreement or some subsequent date. The Charter came into existence after the Lisbon Treaty, and,
yes.
And the Victims Directive is 2012.
Yes, those all post-date the agreement. The Charter wasn't in play at that time. The Victims Directive wasn't in play. There was a previous incarnation, I think, in 2001, but none of that was in play. Again, reading across to the asylum and immigration sphere, we have the Illegal Migration Act disapplied in significant part on the same analysis. There's not a hint anywhere in the Belfast Agreement that that was an issue for any of the participants at the time in 1998 in Northern Ireland. Yet, that is the area that is now most contested through this the lens of civil rights. In our submission, we get to that position whether it's a Vienna Convention law of the treaties case or not, but we say, for the reasons I've already outlined, it's not, and the agreement falls to be construed in the ordinary way. So the scope question...
Can I just ask, on the point that Lord Stevens just asked you about, is your response on the one hand, well, the obligation in Article 2.1 is a do not diminish, therefore it's a standstill obligation, if there is an obligation at all, that it's a standstill, or do you point to the provision we saw earlier to the effect that union law is treated as a sort of as an evolving entity?
It's a non-regression clause, primarily, my Lord, so it's a floor below which we should not descend, because that floor is what supported the Belfast Agreement when it was enacted and supported the peace process. It doesn't need to have dynamic alignment. The dynamic alignment applies to the other corpus of laws that I've identified in Articles 5, 7 and 10. Now, the breadth of the case made against us is civil rights brings everything in. Not only that, it brings it in with the concept of dynamic alignment. So it's not just the rights that we contemplate now, it's the rights that come in the future in a context where we cannot exercise a democratic consent mechanism to extract ourselves from this position.
So ensure no diminution means ensure you keep up.
Yes. That's the contention. So
Ensure, keep up with what?
whatever the body of civil rights law is at any time in the future in respect of the, through the civil rights portal. We say what's intended was the anti-discrimination norms, there are examples given, we shouldn't drop below that floor in the future. That's the position.
So, I've lost it, I'm afraid. Are you saying that the rights that are referred to in that part of the Belfast Agreement are static? Those are the rights at the date. Those were the rights that were necessary to secure the agreement. Or are you saying that they can be added to subsequently?
They can be added to, my Lord, yes, because the Annex 1 corpus, for example, can be updated as the norms change. So that can change. So the floor that's identified there, yes, that can change. But again, we say it was never in contemplation that the entire corpus of civil and political rights would come in through the agreement. The case against us is it does, and it is to be dynamically aligned and develops as we go.
Earlier you referred us to, I'm sorry. No, okay. Earlier you referred us to a provision which made clear that it was the changing content.
Yes.
Could you remind me what
Article 13.3 of the Windsor Framework document, Lord.
Thank you very much.
Can we just, like Lord Stevens, I'm finding it's difficult to follow. Okay, let's be quite clear. On the one hand, we've got Article 2.1 of the protocol, which is on page 10751, which is an obligation to ensure that no diminution of rights as set out in the specified part of the Belfast Agreement results from withdrawal from the Union. Okay.
Yes.
And then the other provision you've just referred us to is Article 13 of a protocol.
Yes. Page 10759.
Which only refers to acts.
Yes, Union Acts. So the Annex 1 directive.
So civil rights don't have to be updated in accordance with emerging EU norms.
That's what we say. The argument against this is well, it's clear what's intended here. Dynamic alignment of Union Acts. Annex 1 contains 6 Union Acts.
So it's Article 13, paragraph 3 that you're
Yes.
taking us to.
And yet you're putting emphasis on the word that where there's a reference to a Union Act, that is dynamic because it can be amended.
Yes.
But you say that doesn't extend across to the concept of civil rights.
Well, the concept of civil rights doesn't even appear in Article 2.1, so it's you get there by extrapolation through the external source.
Yes.
So you've got to go through several more steps before you get to that target. But what's pretty clear is what 13.3 is saying.
In a situation where a new act is adopted is addressed in paragraph 4, paragraph 4 of Article 13.
Yes.
Well, the Union adopts a new act that falls within the scope of this protocol, but neither amends nor replaces a listed Union Act. Then the UK has to be informed. The Joint Committee holds an exchange of views. And so the matter is taken forward through the mechanism of the Joint Committee.
Yes.
So where does that leave us in relation to the Victims Directive, which really comes along in 2012?
Yes. Good question. Well, I was about to move to that, which is the second dimension of the case. I've probably said what I have to say about scope. The Victims Directive isn't an Annex 1 directive, So it has to come in by some other route. When these cases first started out, there were a plethora of EU norms in play, but as the case has gone on, it's crystallised down to the Victims Directive being connected either through paragraphs 11 or 12 or the civil rights paragraph in the RESO section of the Good Friday Belfast Agreement. The Victims Directive itself, again, it is, we say, necessary to look to the treaty root of the Victims Directive to understand where it comes from and what it does. And you'll find the Victims Directive at, well, perhaps first the treaty. If you go to, in your electronic pagination, 10675.
Can you give us that again, please?
10675.
Thank you. And you say this comes in via, did you say Article 12 of the Belfast Agreement?
Paragraph 11 or 12 of the RESO chapter or the civil rights sentence. So
675.
Yes.
What are we looking at there?
That is the treaty. This is the TFEU. And just, again, put this in the list of key things you need to see. This is Chapter 4 of the treaty, Judicial Cooperation in Criminal Matters. Article 82 provides for judicial cooperation in criminal matters in the Union, based on the principle of mutual recognition of judgments and judicial decisions, shall include the approximation of laws and regulations referred to in paragraph 2 and Article 83. Looking across to the next page, to the extent necessary to facilitate mutual recognition of judgments and judicial decisions, so forth, matters having a cross-border dimension, the Parliament and Council may enact directives which concern a number of things, including, at subparagraph C, the rights of victims of crime, and B is the rights of individuals in criminal procedure. I show you that because that is the treaty source for the Victims Directive. Again, nature and purpose being important here.
Mr. McLean, I'm sorry to interrupt you, but I'm still trying to track down your telling me that the Victims Directive comes in via Articles 11 and 12 of the Belfast Agreement. I can't...
RESO section, my lord, the rights, safeguards and equality of opportunity section. Which
it's alleged to come in.
Alleged to, yes, sorry, that's the argument.
I thought you were conceding for a moment.
No, not at all. No, sorry.
No. Okay.
Robustly not conceding that point. The only way it can come in is via those parts of the agreement. I'll find the pagination for that. 10989. So, and then I showed you the treaty.
Oh, I see. The argument, the paragraphs about reconciliation of victims of violence.
Yes.
Yes, it's the argument against you. You were telling us how the treaty brings in the Victims Directive, and you were referring to 10989 as being the argument against you that these provisions bring the Victims Directive in.
Exactly. Yes.
The agreement. I think that's the. Okay.
Yes. I'm not accepting that as a proposition. That's the.
No, you're not. You're
I'm
saying you certainly don't get there, but you will hear from others who say, no, you do, and this is the way it's done.
Even though the Victims Directive wasn't in existence at the time.
Exactly right. Yes, that's it.
But did the Victims Directive go through any Article 13.4 procedure with the Joint Committee?
I think the answer is no to that, Lord, but I will check that position. I think
isn't Article 13.4 looking to the future after the United Kingdom has left the EU?
Once you've left, the committee's up and running.
After we've left, yes.
Yeah. So it's new events that happen post-exit. Yeah. So I don't believe it did.
Yes, of course.
I'm still not clear, Mr. McLean, what you say about on the temporal point, about the fact that the Victims Directive was introduced only in 2012.
Yes.
I mean, is that another reason why it can't form a part of
It certainly is. Now, there's a precursor, I think, at 2001, as always with these directives, at earlier iterations, but I don't think anything goes back prior to the enactment of the Belfast Agreement. So we're looking at EU norms that post-date the Belfast Agreement. It will be said against that that doesn't matter, because the intention is, through the RSEO approach, to capture things which tie into victims' rights protections or matters of that nature. So there is a counter-argument to it. But it is right that temporarily it wasn't in contemplation at the time of the enactment of the bill.
So you are taking the time point.
Yes.
And you're not accepting that it's cured by 13.3.
No, it's not.
Thank you.
So now I've completely lost my way. But I was showing you the treaty, because the Victims Directive source is Article 82 of the treaty. The point being, that's all about mutual recognition of judicial processes. So it's not about substantive criminal law or anything of that nature. Then I wanted to look at the Victims Directive itself. You'll find that at page 5584. So this is a 2012 directive, tied back to Article 8.2 of the treaty. You see that at the top of the page on the left. Establishing minimum standards on the rights, support and protection of victims of crime, and replacing the 2001 Framework decision, which is what I was groping for as the precursor to that. The recitals are important. Recital 1 sets the objective: developing freedom, security and justice, the cornerstone of which the mutual recognition of judicial decisions in civil and criminal matters. Recital 3 refers to Article 82.2 again, which I've already shown you. Recital 26 descends into detail about what's engaged. When you're providing information to victims, sufficient detail to be given to ensure they're treated in a respectful manner, to enable to make them informed decisions about their participation in proceedings. In this respect, information allowing the victim to know about the current state of any proceedings is particularly important. It's equally relevant for information to enable a victim to decide whether to request a review of a decision not to prosecute. So this directive is in part directed at the rights of victims in circumstances where there is a prosecutorial process. We have to tie that back to the Legacy Act in order to make sense of all of this. The point that is made against us is that the primary legislation enacting conditional immunity provisions is, in substance, a decision not to prosecute. That's what the Human Rights Commission say. In substance, a decision not to prosecute at a policy level. And that runs counter to the rights of victims in this directive. And we say that's wrong for reasons I'll come to, but just to capture the point in respect of recital 26. Recital 43, you see the right to review a decision not to prosecute should be understood as referring to decisions taken by prosecutors, investigative judges or law enforcement authorities such as police officers, not the decisions taken by courts. So this is all familiar to us. We've all been involved in cases reviewing prosecutorial decisions by judicial review. That's what's in play here. But no, what is said against us is no. Actually, we have a higher level policy-based decision not to prosecute because you've introduced through an Act of Parliament a concept of conditional immunity. And that concept of conditional immunity cannot sit with the Victims Directive and should be disapplied. That's the argument that was ultimately accepted by the High Court and accepted by the Northern Ireland Court of Appeal. So looking into the provisions, if you go forward to 5592.
All of this matters not if there is no direct effect.
Yes. Scope can be a complete answer to the case. If scope's not a complete answer, then we say the Victims Directive application deals with that particular issue. So
you have to find an underpinning under EU law. This is the alleged underpinning. It has absolutely no relevance at all to immunities.
Yes. That's our position, Lord.
So we've moved from the question of the direct effect of Article 2 to the question of breach.
Yes, whether there's been a diminution.
But that in itself brings up the question of the direct effect of the victim
Does.
directive.
Exactly right, Lord. We say you have to look at it at again, a tiered level. So is Article 2.1 directly effective? Is the Belfast Agreement component directly effective? Is the Victims Directive directly effective?
Yes, but they go to different issues.
They go to different issues, exactly. But each of those has to be analysed.
It's confusing to describe them as three tiers of the same inquiry, because we're now concerned with the question of diminution.
Yes, we are.
Yes.
Although I don't want to give away the fact that there still is a freestanding question about whether the Victims Directive has direct effect.
Yes, that in turn leads to the question
Yes.
of whether the Victims Directive does have it.
I think what I'll focus on in the time I have available is the question of diminution, as to whether or not there is a diminution of whatever the rights are in the Victims Directive. That's, which, my Lord's right, that's the next question in the debate.
Thank you.
The objectives are important. They're set out in Article 1, is to ensure victims of crime receive appropriate information, support and protection and are able to participate in criminal proceedings. So again, the conceptual flaw in the argument against this is that this all presupposes criminal proceedings. It mandates that they exist. It cuts against immunity. We say, no, that's not the case. This provides procedural rights in circumstances where there are criminal proceedings, where there is a decision to prosecute. That's where the rights are actually engaged. And you'll see that when you look into the actual detail of the operative provisions. There are two provisions relied on here. They are Article 11 and Article 16 of the Victims Directive. You'll find those firstly at page 5596 for Article 11. This all falls under the heading in Chapter 3, Participation in Criminal Proceedings. So Article 10 is about a right to be heard. So victims shall be heard during criminal proceedings, may provide evidence. Procedure rules about that. Article 11 provides rights in the event of a decision not to prosecute. Again, we can, I don't intend to spend time on it, but we can go through a direct effect analysis here. You'll see member states shall ensure that it's programmatic. In accordance with their role in the relevant criminal justice system, have a right to review a decision not to prosecute. The procedure rules for such a review shall be determined by national law. You'll see some of the features there that have resulted in a finding of no direct effect. Programmatic, not particularly clear, and requiring some ancillary steps to be taken. So it's not a given that this provision has direct effect. But the character of the rights is important here. You'll see in 11.2, victims should have a right to review, at least in serious crimes, of a decision not to prosecute. They should be notified of the right to receive information. These are all rights that are engaged in circumstances where there is the possibility of a prosecution. They don't mandate that there must always be a prosecution. They don't contend that there can never be immunity. And that has to be right, because we know in our criminal law, outside the Legacy Act, there are immunities. Section 71, Serious Organised Crime Police Act, provides for immunity for assisting offenders. They will not be prosecuted if they meet the tests in the Act. There are similar provisions for covert human intelligence sources. They will not be prosecuted for engaging in illegal and unlawful activities. If the argument against this is right, then those sorts of provisions should be disapplied or cannot be enacted because of the Windsor Framework. We say that has to be wrong, because these provisions are not speaking to the content of criminal law. They're speaking to the procedural protections that will apply where a prosecution is in train. So,
could you provide me with the page numbers of both those provisions, please?
Yeah.
At some stage, not now, but
Yes.
at some stage.
Can I be clear? Because when you referred to Article 1 of the Victims Directive, you submitted that there is an assumption that there are criminal proceedings. Then when you referred to Article 11, you said there was the possibility of criminal proceedings. Is the latter enough?
no, my Lord, sorry. There have to be proceedings. These are procedural rights in the context of proceedings.
So you're withdrawing the,
Yes, I've probably misspoken.
the comment about
Yes.
possibility. I didn't see how the two could sit together.
I'm sorry.
Okay.
So, Article 11 is one of the provisions. Article 16 is the other. So this is a right to a decision on compensation from the offender in the course of...
Before we go to 16, just looking at Article 11 first. If one takes 11 paragraph 1 as an example, it places a duty on member states to ensure a right to review of a decision not to prosecute. It then says the procedural rules for such a review shall be determined by national law.
Yes.
So, absent national law, could a party simply rely on the directive?
Well, that does beg the question, whether it gives rise to direct effect.
Yeah.
Do we meet the standard test? Our submission is no in respect of that. It's not sufficiently clear and precise. But I think the focus of our argument is really on the next stage. Even if it is directly effective, you don't get to diminution of rights.
Well, at the moment, I mean, it looks to me as if direct effect may be a bit of a problem in relation to Article 11, paragraph 1 and paragraph 2 for the same reason.
Yes.
Okay. Or do you want to take us to to Article 16?
Yes. Article 16 is a different, it's in the same section, so we're still dealing with participation in criminal proceedings. It's a right to decision and compensation from the offender in the course of criminal proceedings. So where there are such proceedings, victims are entitled to obtain a decision on compensation by the offender within a reasonable time, except where national law provides for such a decision to be made in other legal proceedings. So again, this doesn't mandate that there must be a prosecution or that there must be proceedings. What it indicates is that there should be a mechanism for compensation in the event that there are. We say those facilities remain in place. Now, when we're analysing...
In a nutshell, what you're saying is that it isn't outlawing an amnesty which would exclude the possibility of prosecution completely.
Exactly.
And that's why you say no diminution.
Exactly right. And that's why we have to tie all of this back to what are we actually arguing about in the Legacy Act? What are the provisions that are in play here? And if you go to the Act, that's at page, you have the full Act, I think, beginning at page 5 to 38. This is all about the conditional immunity provisions. And the conditional immunity provisions begin at page 5 to 78 onwards. So you have section 19, page 5278, and you'll see this is a conditional immunity scheme. The Commission, ICRIR, must grant immunity if certain conditions are met, A to C, those are all set out. It's a discretionary decision made by a request panel. If the criteria are met, they will grant immunity. The immunity can be revoked by a court. That's section 26 of the Act. Don't ask you to go to that. But the entire scheme is set out in sections 20 through to 22. So discretionary judgments are made by an immunity panel applying criteria which may or may not afford immunity, which can be revoked. If it's not afforded, there will be a prosecutorial process. If it's revoked, there'll be a prosecutorial process. If that's right, the rights attached through Article 11 of the Victims Directive will be available. Nothing will be removed. If they are available in domestic law, nothing will be diminished. So we say, ultimately, this aspect of the argument fails on the no diminution dimension. And you will see the elaborate arguments which the commissions and the respondents develop to try and evade these points. They say actually, the enactment of sections 19 through to section 22 is, in substance, a decision to prosecute or a decision not to prosecute. So the wholesale policy level act is a decision not to prosecute. That cannot sit with the requirements of the Victims Directive. Therefore, through the civil rights portal in the Belfast Agreement, it's appropriate for a court to disapply those provisions of the Legacy Act, even though analogous immunity provisions exist. Serious Organised Crime Police Act. Analogous provisions existed when the Belfast Agreement was signed in 1998, because one of the precursor statutes was an arms decommissioning statute. So one of the foundation stones of the peace process was an arms decommissioning statute which allowed for immunities if you provided weapons and information to the state. So the concept was in contemplation when the Belfast Agreement was signed. That's one of the building blocks. The concept is threaded through aspects of our criminal law. We say it does not abide with the Victims Directive in any proper sense. And we say this does not provide a proper basis for this application. The point is clear. And there are and will be prosecutions arising even after the Legacy Act, even after whatever the bill is that we're about to have taken through Parliament. Where there are such prosecutions, then the rights to review are available. We have a Victims Charter which provides for those rights. The Public Prosecution Service takes those decisions and is subject to judicial review. All of that remains available. So the core concepts of the Victims Directive, procedural concepts as they are, remain intact. So that, we say, deals with the no diminution aspect of the case. You have my submissions on scope, and you have my submissions on the no diminution aspect. I'll deal next with the charter issues and the points that are likely to be raised in the cross appeal. I've already indicated several times that the evolving nature of the argument here in this case has been to introduce the wider charter rights through the gateway of the civil rights component of the Belfast Agreement. And the High Court accepted that argument. The Court of Appeal rejected it and reversed that aspect of the judgment. So that's the subject of the cross appeal. Again, source documents are the charter itself, which you'll find at page 5580, extracts in your bundle. The scope provisions of the Charter are the provisions that are important for our purposes. They're at 5583. You'll see that the provisions of the Charter are addressed, this is Article 51, to the institutions and body of the Union with due regard for subsidiarity, only when they're implementing Union law. And then Article 52, sub 3, you'll see the correlation between Charter rights and Convention rights enshrined there. So one of the questions for us in examining this issue is whether or not, when we're looking at the specific provisions of the Legacy Act, and in this context it is, I think, Section 9 and Section 43, I'll check that. Is that Act implementing Union law? If it's not implementing Union law, then it's difficult to see how Charter concepts are engaged at all. But we'll come back to that point. So implementing Union law is a key concept.
You referred us to Article 51.1.
Yes.
And you also referred us to another article.
52.3, my Lord.
52.3, thank you.
So 51.1 begs the question, which is whether the contested provisions of the Legacy Act involve the implementation of union law. And I'll come back to that. Another contextual point is, and I'll not turn the provision up, but Section 5.4 of the Withdrawal Act states that after withdrawal, the Charter no longer applies. That's not a...
I was going to ask you about that.
Yes. Well...
surely that must be read subject to the provisions, the machinery of withdrawal
Yes.
itself makes provision.
There is facility for... That's not an absolute norm. There are ways back in from that. But again, looking at the headline point is Charter doesn't apply. It has to be brought in through other mechanisms. And one of the mechanisms relied upon here is the Belfast Agreement and the Civil Rights Portal as such. First point, though, is whether or not we are involved in implementing union law. So back to the Act.
Get into this at all if there's no direct effect.
Yes.
This is an argument that only arises if there is direct effect.
Yes, that's right, Lord. So scope is key to this. If our analysis is right on scope, all of these collateral problems fall away. It's only if we're wrong that we're into any of this territory. Section 8 of the Legacy Act. You'll see at page 5255. Refers to the admissibility of material in civil proceedings. So this is where individuals come forward to the Commission and provide information about an atrocity in the past, perhaps in pursuit of an immunity. The question is whether or not that material can then be used in any civil proceedings, the discharge of those functions. So it's protection in respect of that. I'll pose the question rhetorically, does any of this involve implementing union law, EU law? We say not obviously so, and if that's the case, that's a difficulty for the analysis. The other provision that's in play here, and there only are two provisions that are live on this point in the argument, is Section 43, which you'll find at page 5326. And this is a provision which bars bringing civil actions after a particular date. So troubles-related civil action may not be brought on or after the day in which this section comes into force, and then it defines what a relevant troubles-related civil action is. So it's a kind of limitation provision which prevents the initiation of civil actions. Of course, these civil actions will be relating to the Troubles, which is a defined term in the Act, and the latest date of the Troubles on the Act is in 1996. So the claims in question will be 1996 vintage or earlier, and the provision prohibits their continuation. Question again, rhetorically, is there anything involved here that engages the implementation of EU law? In our submission, that's a difficulty for the respondents, not obviously so.
What's the union law definition of scope, insofar as they've interpreted implementing as being within the scope?
In the Court of Appeal, you mean, on the...
No, in the Court of Justice of the European Union.
Well, I might have to come back to you on that one, or I'll reflect on that point. The argument against us is that there is some authority suggesting a very expansive interpretation of implementing union law, and what's relied upon in particular is a judgment of Lord Kerr in the Rugby Football Union case. I don't think I'll give you the reference for it. It's at 7959. Supreme Court decision from 2012.
Are you going to come back to Section 5.4 of the Withdrawal Act?
Yes.
It's important we understand where that stands in relation to the matters we're dealing with.
Yes. I'll come back to that. I'll deal with the EU implementing law point, and then I'll return to that for me. So, I don't intend to go through Lord Kerr's judgment in Rugby Football Union case, but it's relied upon as adopting an expansive approach to when there is an implementation of EU law going on. We say that authority has been overtaken by a number of later decisions which retreat from that position, and I was going to take you to the Hernandez judgment, which is at page 9424. 9424. So this is a CJU decision on the applicability of the Charter. It's a 2014 decision. And I'll take you to the core part of the analysis, which is from paragraphs 32 onwards. This is all about the scope of Article 51 of the Charter.
Page?
This is now 9431, my Lord.
Sorry, 9?
431. And the statement of principle that I'm taking from this is to be found in paragraph 34. So CJU are saying it should be borne in mind that the concept of implementing union law, that's in...
Where are you reading?
Sorry, my Lord, this is paragraph 34 on page 9431. In this regard, it should be borne in mind that the concept of implementing union law as referred to in Article 51 of the Charter presupposes a degree of connection between the measures of EU law and the national measure at issue, which goes beyond the matters covered being closely related or one of those matters having an indirect impact on the other. So some tangential collateral impact is not going to be sufficient. Paragraph 35. In particular, the courts found that fundamental European Union rights could not be applied in relation to national legislation because provisions of EU law in the area concerned did not impose any specific obligation on member states with regard to the situation at issue in the main proceedings. 36, halfway down. The mere fact a national measure comes within an area in which the European Union has powers, cannot bring it within the scope of EU law, cannot render the Charter applicable. 37. It's necessary to determine whether the national legislation is intended to implement a provision of EU law, the nature of the legislation at issue, and whether it pursues objectives other than those covered by EU law, even indirectly affecting EU law. So, back to sections 8 and 43 of the Legacy Act. These are the analytical tools which we must use. There's no reference to EU law in those provisions. It's not indirectly engaging, or we say even tangentially engaging. So there is no EU law being implemented in the context understood by the CJU in Syracuse. Further authority on the point.
Could you repeat the sections you were referring to?
Section 8 and 43 of the Legacy Act.
The ones
I'll give you the page reference for those. Section 8 is at page 5255. And 43 is at 5326.
Thank you.
A more recent CJU decision, again on the same point, is a case of Saragossa, which is at page 10224. And the statements of principle here, which are of relevance for our purposes, are found at page 10228. Again, the analysis in respect of Article 51 of the Charter. It should be borne in mind the concept of implementing union laws referred to in Article 51 requires a certain degree of connection above and beyond the matters covered being closely related or one of the matters having an indirect impact on the other. In order to determine whether national legislation involves the implementation of EU law,
I'm sorry, which paragraph?
it's now 24 and 25, more at the bottom of page 10228. Points to determine whether the legislation...
Paragraph 25.
25,
25, thank you.
at the bottom.
24 and 25,
Yes.
yes. You were reading from 24.
Reading from 25 now, yes.
You're now reading 25, yes.
So we look to the nature of the legislation, the objectives pursued, paraphrasing now. 26, courts found that fundamental EU rights could not be applied in relation to national legislation because the provision of EU law concerned did not impose any obligation on member states with regard to the situation at issue in the main proceedings. And then paragraph 30, there's nothing to suggest the provisions of Legislative Decree 4204 in that case fall in the scope of EU law. Those provisions do not implement rules of EU law, a fact which distinguishes this case from the present from that which is a preliminary ruling made. And it's important to consider the objective of protecting fundamental rights in EU law, which ensure those rights are not influenced in areas of EU activity. So again, we say, in common with the decision in Hernandez, and keeping a sharp focus on the provisions of the Legacy Act that are in play here, sections 8 and 43, there's none of the indicators for the implementation of EU law can be found. The Court of Appeal agreed on that point, and we endorse that aspect of their reasoning. That's the subject of the cross appeal. Those are the only two provisions that are relied upon in that regard. So sections 8 and 43 is applied solely on the basis of the charter engagement, not because of the victims' directive engagement. But again, the corollary of the argument, if it's right on the cross appeal, is that we bring in the full panoply of CFR rights through the same mechanism. Complete answer to that, of course, again, takes it back to the point Lord Stevens has made to me. If we're right on scope, then that answers the cross-appeal point anyway. You don't get to any of this if it's not within scope for the reasons that I've outlined. Lords, there's one or two points I want to check. I see it's just about 1 minute to 1.
Yes, well, if that's a convenient moment, Ms. McGleenan, we'll adjourn and resume at 2 o'clock.